All rise. Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. You may be seated.
Good morning to all. We want to welcome you to the Tennessee Court of Appeals. This morning, I understand we may have some observers this morning, Madam Clerk?
Yes, sir. We have some observers from the University of Tennessee.
We want to welcome you. Madam Clerk, are there any preliminary matters this morning?
No, sir, Your Honor.
In that case, I ask that you would please call the first case.
Michael Frisbey et al. Versus Salem Pointe Capital LLC et al.
I will also remind the parties that these proceedings are recorded, so you may want to bear in mind as you make your presentation what you say and don't say, because once it's out, it will be out, okay? So this morning, your panel this morning is Judge Friesen from my right, Judge Davis to my left, and myself, Judge McClarity. For the appellant, are you prepared?
Yes, sir.
Will there be one argument or two arguments?
There will be one argument for the appellant, and I would like to reserve 5 minutes for rebuttal.
You may do so.
Good morning, Your Honors. My name is Brandon Morrow of the Knoxville Bar, and I, along with Tom Hill and Adam Russell, represent the appellants in this case, Salem Pointe Capital and Michael Ayers. Salem Pointe Capital is the declarant of the Rarity Bay community down in Loudoun and Monroe counties. Mr. Ayers, also our client, and his wife own Salem Pointe Capital. In 2015, Salem Pointe purchased the golf course, country club, condominiums, vacant unplatted land, and the declarant rights in the Rarity Bay community out of a federal court receivership. These declarant rights motivated Salem Pointe's purchase of those assets because holding these declarant rights ensured that it could protect its investment in the community. Now, fast forward to 2022. Mr. Frisbey, the plaintiff in this case, was elected to the Rarity Bay Community Association Board of Directors. Thereafter, he was removed from the board by Salem Pointe Capital pursuant to bylaw provision 8.5, which gives the declarant the right to remove directors. Mr. Frisbey then sued to invalidate section 8.5 and be reinstated to the board. After a bench trial, the trial court entered an order dated March 16, 2023. This is the order from which we appeal. This order contained arguments and theories that neither party had briefed. It relied on statutes that have no application to this case. It even invalidated a bylaw provision that was never at issue in this case. But Your Honors, perhaps most egregiously, the trial court misquoted a statutory provision in a material way. We filed a motion to alter or amend the March 16th order to, for the first time, address some of these issues that were raised in the trial court's order. In denying our motion, the trial court stated that it had already considered these issues. With all due respect to the trial court, that was somewhat impossible because those issues had not been raised. We were responding to them for the first time. For purposes of today's argument, I think we can condense our discussion to 4 issues, the first of which is whether the trial court's March 16th order should be reversed because it violates the party presentation principle. The second is whether the trial court erred in determining that bylaw section 1310A, which gives the declarant the right to amend the bylaws, was inconsistent with state law and the charter. The third issue is whether the trial court erred in determining that section 8.5 of the bylaws, which gives the declarant the ability to remove directors, was inconsistent with state law and the charter. And the fourth and final issue is a factual issue. The trial court found, and erred in doing so, that Mr. Frisbey did not receive proper notice of the meeting at which he was removed from the board. The trial court made this finding despite the record being clear that Mr. Frisbey received an email days before notifying him of the purpose of the meeting, where the meeting was to take place, when it was to take place. And there is no dispute in this record that Mr. Frisbey actually attended that meeting. Turning to the party presentation principle. This is a concept that has been strongly endorsed by the Tennessee Supreme Court. It stands for the proposition that it's the party's job to present issues and arguments to the court. It's the court's job to then decide those. Courts are to be neutral arbiters. They're not advocates. They decide the issues put before them. They don't construct those issues or arguments themselves. But that's not what happened in the court below. The trial court sua sponte invalidated section 1310A of the bylaws, which gives the declarant the right to amend the bylaws. This was not an issue that was present in this case prior to the trial court's issuance of its March 16th order. But the trial court reached this holding anyway. And I think the question before you all is, well, is this enough to constitute a reversal? Is this an abuse of discretion? The Tennessee Supreme Court says it is. If we look at State versus Bristol, 654 Southwest 3rd, 917, this is a 2022 case. There, the Tennessee Supreme Court held that the lower court, and I'm quoting, abused its discretion in sua sponte raising and deciding an unpreserved and unprecedented issue without affording the parties notice and an opportunity to be heard on the matter. And that's what happened below in this case. Now, as we turn to talk about these two bylaw provisions, 1310A and 8.5, I think it's important to keep in mind a statute that should really guide this discussion, 4852-106B. That statute provides that the bylaws of a corporation may contain any provision for managing the business and regulating the affairs of the corporation that is not inconsistent with the law or the charter. This statute's important for two reasons. First, it gives nonprofit corporations wide latitude to craft their bylaws. The question is not whether the charter or the state law allow a particular bylaw provision, but rather whether a particular bylaw provision is inconsistent with the charter or state law. And at the trial court level, this was an analysis that got muddied time and time again. Second, I think what you're likely to hear from my colleague on the other side of this case is that if the trial court had not invalidated these bylaw provisions, my clients could grant themselves whatever power they want to. But that's not the case, and that's not our position. This same statute acts as a check on that sort of power. Only bylaws that are not inconsistent with state law or the charter can be enacted. And so it's important to remember this as we turn to 1310A. 1310A in the bylaws says that until termination of the development period, the declarant may unilaterally amend these bylaws for any purpose. I think it's incredibly important to point out, and this is something the trial court got wrong, this was not a power that our clients created out of whole cloth for themselves. This was a right that had existed in the Rarity Bay bylaws since 1998, long before Salem Pointe Capital became the declarant in this community. And this was a right that the board of directors gave directly to the declarant, and that has been in place since 1998.
Mr. Morrow, let me ask you, did the trial court invalidate that provision of the bylaws because of 4860-301, which says the charter may require an amendment to the bylaws to be approved in writing? Is that the basis for the invalidation of that section? Best I can tell from the trial court's opinion, that's exactly right, Judge Davis. So what the trial court held, and this is in the record, volume 2 at 170, that the charter does not allow a third party to amend or repeal the bylaws, and that under 4860-301, the statute you referenced, that power was not reserved in the charter for the declarant. Let's talk about that statute, 4860-301. That statute deals with a situation where either the members or the board amend the bylaws, and then it requires approval by a third party, a declarant or someone else. That's not the situation we have here. Under 1310A, the declarant, as long as this amendment happened during the development period, the declarant could amend directly and unilaterally. So 4860-301 doesn't apply.
The trial court also erroneously held that the declarant could not amend the bylaws without the approval of the board. It relied on 4860, 201, and 202. But all those statutes say is that the directors may amend the bylaws. It doesn't say that only the directors can amend, and it doesn't say that third parties are prohibited from amending. The trial court went on to hold that amending the bylaws by the declarant was inconsistent with 4858 101B. Now, that statute provides that all corporate powers shall be exercised by or under the authority of the board, but it doesn't require the board to act directly. It plainly states that powers can be exercised under the board's authority. That's what happened in this case. In 1998, when the board adopted the original bylaws and ceded to the declarant the ability to amend those bylaws, that's what was happening. The declarant can act under the authority provided to it by the board.
Let me ask you this. So what authority or application, if any, do the general statutes regarding corporate governance for nonprofits have if the LLC in this case can put in their, I can do anything, one person can do anything? Do any of the corporate governance statutes apply, and can you do that?
Absolutely, Your Honor. So I think that takes us back to the statute we talked about just a second ago, which is 4852 106B, which the declarant can amend and can take certain actions, but it can't do anything that's inconsistent with the state law or the charter. And when we look at that analysis, we have to remember that this statute prescribes wide latitude for bylaws to be adopted. If the Nonprofit Corporation Act does not have to enumerate everything that a nonprofit corporation can do. Instead, it opens it up and says, you can adopt any bylaw you want as long as it's not inconsistent with the state law or the charter. One final thing, I'm about to run out of time here, but one final thing I will point out is with regard to 8.5, the trial court misquoted the statute. The trial court held that only the members can remove directors. And that's simply not what the statute said. It misquoted it, and that's a material and reversible error.
You have your time for rebuttal.
Thank you, Your Honor.
Yes, ma'am.
Thank you. May it please the court, I'm Melanie Davis from the Blount County Bar, and I'm here on behalf of the plaintiff appellees, Mike and Jamie Frisbey. This case involves whether a single person, in this case Michael Ayers, as the representative for Salem Pointe Capital LLC, which is the claimed declarant or developer in Rarity Bay, has the unilateral ability to overturn the results of an otherwise valid election from a not-profit homeowners association. Here, Mike Frisbey was elected by the people to the board in 2022. However, the managing member of LLC, Mr. Ayers, who also ran for a director position but lost, decided that those hundreds of votes from property owners should be disregarded because he didn't like that Mr. Frisbey didn't, in his mind, comport with his idea of what a director could be because he didn't support developer rights sufficiently, in Mr. Ayers' opinion. So, Mr. Ayers purported to remove Mr. Frisbey from his board position. The focus ought to be on TCA 4858-108E, which deals with removal of directors elected by members. All right, and this is under the Tennessee Not-for-Profit Corporation statutes. I disagree with the analysis by opposing counsel that somehow TCA 4858-106B says that you can do anything under not-for-profit corporation law unless the charter or the laws say otherwise. That's not consistent with the way that this chapter is written. This chapter is written throughout to say, unless the bylaws or the charter provide otherwise, comma, here's the rule. Unless the charter or the bylaws provide otherwise, here's the rule. That language does not appear in TCA 4858-108. It just says, this is the law. This is how you remove directors who are elected by members. And the pivotal part is in subsection E that says, a director elected by the members, Mr. Frisbey, may be removed by the members only at a meeting called for the purpose of removing the director and the meeting notice must state the purpose, and one of the purposes of the meeting is removal of the director. So one of your choices, if you're removing a director, is not to give the unilateral power to one person to override the vote of a majority of the people. That's just not in your choices. If this section said, unless the charter or bylaws provide otherwise, like so many other of the statutes say that are before it and after it, then maybe there would be an argument. But it doesn't say that you can somehow override that provision with the bylaw. And I think
so is it your position, Ms. Davis, that the section of the bylaws that says declarant may unilaterally amend the master declaration and the bylaws for any purpose, that was in place since '98, that it was just invalid per se from the time it was in place?
It's certainly invalid as pertains to provisions that are contrary to state law. We didn't ask in a declaratory judgment action that that provision be stricken or anything to that effect. But I don't think that you can take a bylaw provision, no matter how old it is, and use that to override state law, unless the state law says something to the effect of the bylaws can provide something different than what this law says. So yes, that provision has been there, but it doesn't give anyone the right to say, we know better than the state legislature as to what the rules should be for removing a properly elected board member. As far as this party presentation rule, it's unclear exactly what the application in this case would be, but certainly trial courts have the ability to do their own analysis of the situation, of the case, and to supplement the contentions of counsel through their own deliberations and research. And we have provided the case of Carducci versus Reagan in our brief. And what it says is that the party presentation rule doesn't limit a court to particular legal theories advanced by the parties, but rather the court retains independent power to identify and apply the proper construction of the governing law. So what happened here is the trial court did go a little bit beyond what we originally asked, but when she did that, she was looking at the underlying documents that were the foundation of what she was being asked to do. And that's what happened in the Bernacchi case. That case was about a bank, but the court decided that although party had raised the issue and the court granted it on its own independent conclusion, that that was something that was within the court's province, and that was not in any way violative of the party's rights. We raised these issues, the court addressed our issues, and the court went a step further, and we submit that that's not violation of the party presentation rule or anything else. She simply looked at a different analysis over and above what we did as far as we were specifically focusing on the removal aspect, and she looked on to the powers that gave the declarant the right to basically go in and override any decision of the board or of the members as to whether or not that underlying power was legitimate or not, and she decided that it was not. There was another issue about notice. Even if somehow it was legal to remove my client, there was also an issue about notice. The only notice was given to him was by email. He had not consented to receive notice by email, and that would be required under statutes and under the law cited. And we have cited in the brief transcript provision where Mr. Ayers acknowledges that Mr. Frisbey never gave him permission to give him notice by email. Mr. Frisbey was just newly elected to the board when he received this notice. So there hadn't been time to establish any sort of a situation where the party's action somehow implied that he had been given his permission to communicate notice via email. That wasn't there. He was a new director. This notice was given by email. It wasn't given by the correct person under the bylaws, and it didn't specify who was going to be removed. It simply said that some directors may or may not be removed basically at this meeting, and that the court held was insufficient notice of the fact that the declarant was going to remove a director purportedly at this meeting. So that's a secondary issue. We don't think that that's really what this case should turn on. This case should turn on the power of the declarant to override the vote of the people. The court did go above and beyond what was required and found multiple reasons why it was improper for Mr. Frisbey to be removed from the board. And although we say that those are solid and contain all of them the grounds to uphold what the trial court ordered in its March 16, 2023 order, any of these reasons relied upon the trial court should be sufficient to uphold the ruling in this case. So even if you don't like one of the reasons that the court found that my client should be reinstated to his position on the board, there are other stated reasons why in that order, and we submit that even if one of them is correct, that the order should be upheld. Thank you.
Thank you very much for your presentation. Yes, sir. Your rebuttal.
Counsel for the appellee suggests that the nonprofit corporation framework is limited, and that this is the only way that certain actions can take place. But if we turn back to 4852-106B, that is so important to this case, because any provision may be adopted as long as it's not inconsistent. It does not require this Nonprofit Corporation Act to enumerate everything that an entity like the Rarity Bay Community Association can do. Otherwise, we would have a stack of books a mile long just for the Nonprofit Corporation Act. And so I think we have to go back to 4852-106B. On the party presentation principle, counsel concedes that the trial court went beyond what the lawsuit was actually about. But the appellees say that, well, it was just an alternative theory. It was not. It was a separate issue. This issue of invalidating 1310A wasn't just an alternative theory. It invalidated a separate right that our client held that was not at issue in this trial. Turning to the notice issue. The trial court found that Mr. Frisbey did not receive proper notice at the meeting at which he was removed. But the preponderance of the evidence doesn't support that finding, Your Honors. It is undisputed that Mr. Frisbey received an email from Salem Pointe Capital on February 24th, 2022, stating the purpose of the March 1st meeting. And the purpose was for the pending removal of one and or more board members from the CAI Board of Directors. Mr. Frisbey testified that he understood that email to mean that he and other board members would be removed at the March 1st meeting. It's also undisputed. Mr. Frisbey attended that meeting. This isn't a situation where he didn't know about it and wasn't present. He was there. Even if notice was somehow defective, Mr. Frisbey has waived the notice issue. If we look at 4857-106B, it provides that a member's attendance at a meeting waives objection to lack of notice or defective notice of the meeting unless the member at the beginning of the meeting or promptly upon the member's arrival objects to holding the meeting or transacting business at the meeting. Now, in this case, here's what the proof shows. Mr. Frisbey was in attendance for that March 1st meeting. Richard Hoban, a witness at the trial, testified that Mr. Frisbey ultimately objected to his removal, but his objection did not occur at the beginning of the meeting as required by the statute. Indeed, Mr. Hoban testified that there were two parts to the meeting. The first part was to elect officers, and Mr. Frisbey did not object until the second part. Mr. Frisbey, the appellee in this case, has waived any argument by his attendance at the meeting, and just for practical purposes he was there. But under the statute, he has waived this argument that notice was insufficient. Ultimately, on behalf of the appellants, we would ask this court to reverse the trial court's determination that Section 1310A was invalid. The way the trial court got there was a patchwork of statutes that don't apply to this particular case, and that should have never been an issue in this case anyway. Second, we asked the trial court to reverse the invalidation of Section 8.5, which is the ability to remove directors, and ultimately we would ask the trial court we would ask this court to reverse the trial court's finding that notice was improper. Unless you have any further questions, I'll have a seat. Thank you, Your Honors.
I hear none. Thank you very much. I want to thank both of the attorneys for your presentation this morning. Your case now has been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. Thank you both. You may be excused. And Madam Clerk, will you kindly recess court for about 10 minutes, please?
Yes, sir. All rise. This Honorable Court of Tennessee is now in recess for 10 minutes.